Chapter 21, the Principal-Broker Relationship, Agency. We will continue our coverage of the principal-broker relationship. Remember that agency is created when one person, that's the principal, delegates another, called the agent, the right to act on his or her behalf. There are actually three levels of agency. The first type is the general agency, the right to bind the principal to perform a particular act in a trade or business. This could involve a real estate salesperson acting as a general agent to his or her broker. A universal agency occurs when the agent represents the principal on all matters. In this case, the agent would need a power of attorney to do so. And finally, the special agency that empowers an agent to perform a particular act. The special agency is what we discussed in Chapter 20. The listing agreement, that employment agreement or employment contract between a seller and a broker, is a special agency where the agent's job is to go out and find a ready, willing, and able buyer for the principal's property. There are different ways in which an agent's authority can be created or established. The first, of course, is with a written contractual agreement. Another way that an agent's authority can be established is through an implied method. In other words, is it custom in the industry? It would be implied that the agent has the authority to do so, such as posting signs, a for sale sign, and showing the property to potential buyers, and through an open house. While these actions may not be included in the listing agreement, it is customary in the real estate industry. So this would be an implied method of establishing the agent's authority. Doesn't have to be written in the contract, but since it's customary, it is implied, and the agent has the ability or the power to do so. The agent's authority may also be established via an ostensible method. This means that the conduct of the principal gives the implication or gives the impression that the agent has the authority to do so. In other words, the principal gives some third party the reason to believe that another is his or her agent. And there's an example in our textbook about a plumber coming to someone's home, locking up the home, and then giving the key to a neighbor. The neighbor is the agent, but the agent doesn't necessarily have to be notified. The conduct of the principal gives the impression that the neighbor is the agent. Ratification is an agency established after the fact. Again, it has to do with what a third party believes. An agent may engage in a particular action, and if it's acceptable to a principal, even when there was no agreement in place, the agency is established after the fact. It is what the impression that is given to the third party is, what the third party believes. Estoppel is when a principal fails to maintain due diligence over the agent who exercises powers not granted him or her, and an agency coupled with an interest occurs when an agent holds an interest in a property he or she is representing. The agent must, by state law, reveal his or her interest in that property to all parties. Remember the parties to an agency? The principal is a person who authorizes another to act. Usually that's the property owner. The agent is the person empowered to act by and on behalf of the principal. That's usually the broker. And third parties are the people and firms with whom the principal and agent negotiate. The agent uses his or her skills and knowledge when representing the principal, depending on what the object of the contract is. Most of the time in real estate, we said that the principal is the seller of the property and the agent is the broker. They're using their skills and knowledge to go out and find a ready, willing, and able buyer for the principal's property. In return, the principal will pay the agent a commission for accomplishing this task. The broker has certain obligations to a principal. They must exhibit care, which that means competence and expertise. They must also abide by instructions. They must exhibit obedience. They must obey the instructions given by the principal to the agent, but they must abide by only lawful instructions. Obedience to the principal by the broker is also known as faithful performance. The broker is obligated to provide a detailed accounting of any funds received from the third party that will eventually belong to the principal. And we're going to talk about that in a minute. The broker must also be loyal, meaning that they should always put the principal's interests first. And notice is another obligation the broker has to the principal. All information communicated to the broker must be relayed to the principal. No matter how ridiculous some offers are, or if many offers are coming in at the same time, all the information needs to be communicated to the principal. What we have between the broker and the principal is what's called a fiduciary responsibility. That means that the agent has been placed in a position of trust, responsibility, and confidence. There will be no illegal or secret profits. Between the broker and the principal. In other words, the broker should always put the principal's interests first and not their own. When we talked about on the previous slide about accounting, that means that the broker has to perform a very detailed accounting of all the funds received on behalf of the principal. Commingling is when a broker places money belonging to his client or a customer in a personal account. Rather, any funds, whether it be a check, cash, or something of value, must be placed in a trust account, not in the broker's personal account. Furthermore, any checks received from a third party shouldn't be made out to the agent to avoid commingling. Checks should be made out to the agent's firm. In other words, to the brokerage to which the broker has his or her license placed with. Conversion is the actual use of the client's money. Now, in terms of disclosure liability, and this relates to the third party, there are going to be certain facts that the broker knows. If things are said wrongly with an intention to mislead the third party, that's outright fraud. Furthermore, if something is not said in order to mislead, that too is fraud. That's different from misrepresentation. These are facts that the broker does not know, and they may answer a question from a third party without first checking the facts. Or maybe they might not reveal something and still not checking the facts. In other words, these are facts the broker does not know. That's termed misrepresentation. Some additional obligations to third parties. Brokers, of course, have to reveal lead-based paint disclosures on homes built prior to 1978. They should also warn about red flags. These are things that would warn a reasonably observant agent that there may be an underlying problem. They don't necessarily have to offer why there's a problem or how to fix it, but if observing something that can be seen upon a site inspection, it would certainly have to be revealed to the third party. Another issue is as is. That means that the broker must disclose any hidden defects. If a property is sold as is, all that means is that the seller won't fix those problems. But if there are problems, especially if they are hidden, they need to be disclosed by the broker to the third party. Must disclose hidden defects. Puffing is statements a reasonable person would recognize as non-factual or extravagant. In other words, in case a broker tells a potential buyer, this property has the best view of the canyon, or it is just heavenly. Obviously that's a little extravagant. And a reasonable person would probably not recognize that or try to prove that. But to protect the broker, it's just better not to puff. Now, we also talked about in Chapter 20 that buyers can also have agents in some areas of the country. So in a transaction, you would have a buyer, a seller, a buyer's broker, and a seller's broker. So with buyer agency, here we have the exact opposite theory from the traditional seller representation. The buyer is the principal to the buyer's broker, and the agent owes the care of agency duties to the buyer. Emphasis is on helping the buyer make informed decisions and obtain the desired product, that's the parcel of real estate, at a fair price. Here are some other important agency terms. Well, what are the principal's obligations? Well, in terms of the principal's obligation is, of course, to be forthcoming with details and information regarding the property to the agent. The agent is also due compensation for finding that ready, willing, and able buyer. The principal would also have to reimburse the agent if there are any expenses incurred by the agent that are not related to the sale. Indemnification means that the principal must compensate the agent when he suffers a loss that's not his fault. And duty of performance means that the principal also has things to do in regard to this agreement to accomplish the purpose of agency. A broker will have a sales staff, likely. Some brokers have been acting as middlemen, and this is suggested in your textbook that either the middleman or the non-agency might be the future of real estate brokerage. In other words, bringing two or more people together but not representing either. Likewise, non-agency. The dual agency, which we studied in a previous chapter, was a representation of both sides of the transaction, both the buyer and the seller, by the same agent. That's a conflict of interest. One person representing both sides of the transaction, where the buyer wants to pay the lowest price possible and the seller wants the highest price possible. So dual agency or divided agency represents a conflict of interest, and the only way this could exist is if both the buyer and the seller agree to this. Agency disclosure. Agency relationships can be created without written agreements. Unfortunately, that can create a lot of confusions. So consumers must be informed about who the agent represents so there's a clear understanding of the agent's role in a transaction. Many states now have required disclosure forms. And on this slide, this is a disclosure form used in the state of Texas, where the broker, a seller's broker, provides this document to a potential buyer so that the buyer knows that this broker is not working for them. They're working for the seller to find a ready, willing, and able buyer in return for a commission. On the other hand, when a buyer's broker is involved, this document will be given to a seller to know that that buyer's broker is working for the buyer and not the seller. As mentioned earlier, the seller does have to disclose information regarding his or her property. So they have to fill out disclosure statements, often produced by real estate trade associations. That way, everyone will know about any hidden defects. Some additional agency information: interstate land disclosure statements. This requires developers to give potential buyers disclosures about lots. Federal antitrust laws promote competition amongst brokers, and there are certain laws which outlaw price fixing and boycotting. Price fixing occurs when two or more people conspire to charge a fixed fee, having an anti-competitive effect, while boycotting means that two or more people conspire to restrain competition. Brokers have errors and omission insurance, or they have the ability to purchase this form of insurance which protects them. So brokers pay a premium to insurance companies. The insurance company will then defend the broker, pay legal costs, as well as any judgments against the broker. What does it cover? Maybe it's better if I tell you what it doesn't cover. Errors and omission insurance doesn't cover intentional deception, punitive damages, and buying and selling for one's own account. Some key from Chapter 21 are listed here. Questions? Just let me know.